Santiago versus Wilmington Trust.
Your Honors, I received an email from opposing counsel.
Okay.
I'm not sure how feasible it is, but she proposed that maybe she could participate by telephone. I'm not sure.
Telephone?
I would have no objection to that, but
We have a phone up here?
I don't think.
She was properly notified of the oral argument today. She's not here. So,
She was notified it was going to be live in person.
that's my understanding. I don't
Well, yeah, I mean, I'm looking at the notice that was,
just let him proceed with his argument, and that's it.
yeah, I mean, that's,
Yeah.
I mean, is she saying to you that she didn't get notice of this proceeding, or counsel saying?
That's, I believe, what she said in her email.
Have you all communicated with each other before today about anything pertaining to this case?
Well, to the extent that there were maybe requests for extension of time, we emailed back and forth, but not as it pertains to the oral argument itself.
Did counsel specifically say in the email that they did not receive notice of this oral argument?
She says, I'll read it because I don't want to force it. I was just contacted by the 5th DCA clerk. I was not aware that the oral argument was scheduled in this matter. I have searched my electronic file and do not see notice of same. I will be filing a paper/motion with the 5th DCA to advise of the above. My sincerest apologies. Her most recent email says also that Mr. Peltzman, who's the attorney for the third-party purchaser, likewise did not receive a copy of the notice.
Did he appear?
Would you be amenable to requesting the court reschedule the oral argument? If not, please ask whether I can appear via telephone or video, however the court prefers.
Are you coming to tell us something, Charlie?
No, sir, just in case you need anything.
Is there some way that this counsel can appear by phone here?
We're not really set up for hybrid, Judge.
Yeah, I mean, I don't,
That second email, what was the date of that second email?
When I just read,
Yes.
that was the day I just received.
The one that requested that you inquire as to whether or not there can be alternative means of appearance.
And for the record, Your Honors, I mean, the essence of this case is about the opportunity to be heard. I wouldn't oppose.
Brian, you could let him present his oral argument and then let her present whatever she wants to present in terms of not getting notice. And if that's appropriate, then reschedule the oral argument again. If she can't establish that she wasn't properly noticed, we've got his oral argument on the record and we can proceed. It's up to you, whatever you
no, I
want to do.
mean, he's here. We're gonna let him do that. I
Huh?
mean, and you are,
Mr. Greenlee?
Mr. Greenlee? I mean, Mr. Greenlee's here, so, I mean, it's set. I mean, the fact that the third-party purchaser, they haven't entered an appearance in this case, have they?
I don't believe that.
Yeah, so that counsel not getting notice of an oral argument of which he's not appeared, that's, why would they?
Correct.
Now, we're gonna proceed. The counsel can file, I guess, whatever. Hang on, let me reset. There we go. All right, this is, for our record, 2485 Santiago versus Wilmington Trust National Association et al. Mr. Greenlee is here. Opposing counsel, Ms. Rios is not here. She's indicated by email, I guess, to Mr. Greenlee that she did not get notice of this hearing, although...
And I believe there's a notice in the file dated October 1st showing that notice was sent to all parties, including Ms. Rios.
We haven't received anything from the clerk indicating that she's notified the clerk that she didn't get notice, so I let him proceed with his argument, and then we'll see.
Let me ask, Charlie, are these notices of oral arguments sent by regular mail as well to the parties and counsel?
Electronically, Judge, and the clerk's office is saying there was an acknowledgement of the notification on October 1st.
All right, then. We're good to go. So Ms. Rios's office has provided notice to us that they received the electronic notice of oral argument, which set it for today and at this time.
Yes, sir. In the electronic system, it shows an acknowledgement of the notification.
That's it.
That's
That's it.
That's it.
All right.
All right. All right, Mr. Greenlee, go ahead, sir.
Good morning, Your Honors, and may it please the court. I represent David Santiago. I don't guess I need to reserve for rebuttal if there's not going to be argument on the other side, so
Good thinking.
if it pleases the court, I'll just proceed. The issue in this case is whether or not constructive service of process by publication was proper on the facts of the case. We would submit that it was not. We know from the Benevente case that there are two things that a trial court, when confronting the situation, must determine. First, whether the affidavit is facially sufficient.
Now, that's the affidavit of, let me ask you this, under 49.041, isn't the attorney's affidavit sufficient?
Well, there is I believe the statute makes reference to an affidavit of diligent search and inquiry, if I'm not mistaken, and so
Well, I mean, it tracks the language. I mean, it seems like it's a two-step process. A is the affidavit facially deficient, and if so, then we don't necessarily have to go past that. But if it's facially sufficient, then the next step for the trial court is to see whether the facts actually evidence a diligent search, and that seems to be the scenario here.
Yes, Your Honor, I believe that's correct.
Because it does say, I mean, if I look at the statute, it does meet all the facial requirements of the statute.
We would just disagree, not so much in terms of the language of the statute, but how the statute has been interpreted. For instance, on the affidavit, and I'm referring, Your Honor, there's, if I could just back up, so to talk about the actual facts, there are three affidavits that have been submitted. There's the affidavit for service by publication, and if it pleases the court, I'll refer to this one as the Marks affidavit. It was executed by an attorney, and it was April 8th, 2019. And as an exhibit to that affidavit, there is the affidavit of diligent search and inquiry. And to kind of circle back to Your Honor's question, I think this is the affidavit that has to be facially sufficient, the affidavit of diligent search and inquiry. We believe, I'm looking at it now.
Well, I mean, I don't mean to beat the dead horse, but I mean, 49.041, the sworn statement of the plaintiff, his or her agent or attorney.
Correct.
So it's disjunctive. So the sworn statement of the attorney for service of process by publication, as long as it shows diligent search and inquiry, whether the person's over the age of 18, residence is unknown, thinking about absence, or there's nobody to serve process because the absent or concealed defendant. I mean, it's a form affidavit here from the attorney that appears to track this language. And I mean, so we don't get lost in the weeds. I think your better argument is the lack of a diligent search. What factually happened, as opposed to going down the rabbit hole of this affidavit is you don't like it and then we don't.
Just so we're clear, Your Honor, we believe that we would prevail under either under the first threshold inquiry, we believe we would prevail. And again, this Beneventi case, it's almost, to me, it seems conceptually analogous to like a Franks versus Delaware issue, an affidavit for a search warrant. If they omit information which should have been supplied, that affidavit is invalid. And so I think the same would apply here. For instance, or as in the Beneventi case, if it's, quote, patently inaccurate. Here they say his residence is unknown. They knew his residence. It's in their mortgage servicing records, so that it's patently false to say that we don't know his residence. They say, another averment, he could not be located. Again, they're actively communicating with him during the very same time frame as they're executing this affidavit.
I mean, isn't that your best argument? I mean, basically, your client is saying, I was here. I'm living at the place that's being foreclosed. So you trying to find me in Arizona or other places really is neither here nor there, because I've always been at this residence in Orlando. And it seems your position is, hey, you went out and you did a quote, if we accept the service of processors affidavit, you went out in June of 2018. Mm-hmm. Suit was filed in May of 2018. You went out in June of 2018. You couldn't find me there. Mm-hmm. But it wasn't until almost a year later that they tried to publish, serve by publication. And during that whole period of time, Wells Fargo, the prior plaintiff in this case, was communicating directly with your guy and could have readily said, hey, I know we're in this loss mitigation process, but you just need to be aware that a suit has been filed against you to foreclose on this mortgage, and where is it that we can get you served? We'll still go forward with the loss mitigation and see where that takes us, but you need to have the heads up, and then your client could have made the arrangements to be personally served or waive service or something. And by not doing that in this year period, mm-hmm. that really shows an utter lack of diligent effort to serve the person. Isn't that what this is really all about?
Well, that's quite correct, Your Honor. I would, and it's even more egregious than that, because if you look at, I made a little kind of a timeline. I mean, they're communicating with him very close in time. So the original affidavit, the affidavit, I'll call it the Valinsky affidavit in 2018. So it was July 9th, 2018 is when the Valinsky affidavit was executed. And they have, June 25th, they're emailing back and forth, and that's in the record at page 220. So, I mean, you're talking about temporal proximity to when they're actually claiming that we don't know where this person is, we can't find him. They're actively communicating with him. And in fact, we would take the position also that they're essentially lulling him into believing nothing's happening. We're in loss mitigation here. So it's, what Your Honor said is correct, but in fact, it's more egregious than that. And the due process violation is to me, it's manifest. I mean, you can't, on the one hand, at best, it's the right hand doesn't know what the left hand is doing. At worst, they're actively deceiving him into thinking, hey, there's nothing happening here. Let's try to work out this issue with the mortgage. Again, we have this is back to the temporal proximity. We have the Marks affidavit. It's executed April 8th, 2019. This is the affidavit that Your Honor was talking about, that tracks the language of the statute. Several days later, April 13th, 2019, I mean, there's email correspondence back and forth. It's not just one-sided where they're sending him an email. They're actively coordinating or actively communicating by email. We have a Melissa Myers, an email to Mr. Santiago. That's April 13th. That's only a matter of days after they've executed this affidavit saying, we can't locate the guy. They're saying actually in the Marks affidavit, we can't even determine whether he's living or he's dead. Several days later, they're communicating with him, saying, communicating with him about loss mitigation. So then we have.
So you think that's proof that he was alive?
Yeah, I mean, He is alive. He was alive. They knew he was alive. Again, I don't want to cast aspersions on anybody's character. That this is an attorney at the bar. I trust that the attorney maybe didn't know about this email communication. But again, we don't think it absolves the plaintiff from conducting a diligent search, and we think it actually, in fact, it affirmatively refutes the notion that they conducted a diligent search when they could have, this court said it in Shepard, one obvious place to start is the mortgage servicing records. They had his residence on file. To be generous to Attorney Marks, who executed that affidavit, perhaps he didn't know.
So the mortgage servicing records would have shown that they were communicating with this person during the period of time that they purportedly couldn't find him to serve him, and that apparently you had an evidentiary hearing on this motion to quash was held, and the Wells Fargo representative testified favorably to your position that we didn't contact him or communicate him, even though we had his contact information.
That's correct. The materials that were submitted to the trial court were essentially authenticated by Mr. Santiago, and they weren't disputed by the Wells Fargo representative.
Well, but the judge did make a credibility finding as to Mr. Santiago, but over and above that, you presented testimony from, quote, the other side, for lack of, not Mr. Ward, I understand that, but the actual loss mitigation person, for lack.
That's correct, Your Honor. And if I could maybe shift my attention to the finding of the trial court. After all, we're here to try to assign error to what the trial court did. And we believe that relying on the Ward Affidavit, there's no statutory mechanism for relying on the Ward Affidavit. If you look at the statute, it says the affidavit should be filed by the plaintiff. In this case, the affidavit was filed by the third-party purchaser. And I'm looking at it here.
But Mr. Ward testified, though, right?
Yes, Your Honor, he
I
testified.
mean, let's say Mr. Valinsky was dead, the initial process server.
Okay.
Let's say he was dead, and Mr. Ward says, well, I was with Mr. Valinsky, and I was training him, and he did the affidavit, but this is what actually happened, and here's the evidence of what happened, here's my testimony, and the trial judge buys that as more credible, accepts as more credible than your client's. Wouldn't that be, couldn't the trial judge rely on that?
Well, in that counterfactual scenario, if, let's say, yes, if he had accompanied Mr. Valinsky, if Mr. Valinsky were dead or somehow unavailable, I suppose the trial court could take that as evidence that there was some sort of attempt to make service of process. But if I could briefly draw the court's attention to something that I just realized last night, and I apologize for not including it in the briefing. If you look at, and this is at page 285 in the record, that affidavit was executed on March 17th, 2020.
Right, I saw that.
Yeah, so...
But he's saying that's what happened back in June of 2018.
Right, but again, to effectuate constructive service of process, you need an affidavit, and this affidavit, that can't suffice.
I mean, the trial judge has to look at the affidavit submitted as it's a condition proceeding to allowing constructive service, and obviously that couldn't have been there because it came after the final judgment was entered. It was executed after the final judgment was entered. So that affidavit was not something that trial judge physically could have relied on.
And I would also submit, Your Honor, that it goes to the credibility of Mr. Ward that, he barely recalled. He does 20 to 30 services of process every single day.
Yeah, but the trial judge thought he was credible.
Well, Your Honor, I mean...
Like that or not, or whether that makes sense, the trial judge thought it was credible as opposed to your client's testimony.
Yeah, I would agree, but I would also... I would agree insofar as, yes, the trial court found him credible. Whether that finding is entitled to any deference, I suppose, as far as it goes. Well,
it's the finding. I mean, that's what kind of the rule of thumb.
Yes, it's a credibility determination. So I get it that on appeal, I'm hard pressed to challenge a credibility determination. But in this particular occasion, this is clearly executed in anticipation of litigation. It was after the motion to quash had been filed that this was executed. And he's talking about events that were 2 years, previous to that.
Well, but
So-
the judge found him credible when he said, this, I know my affidavit is this date, but this is basically what I remember, and the judge could have said, well, how could you remember something? You've served 5,000 people since then, and for whatever reason, the judge thought that was credible, and that's really neither here nor there at our point. Whether you like it or not, or whether we would have found it credible as well is not really the issue at this point.
And I agree with Your Honor that it's not really the issue. And the reason why it's not really the issue is because no matter what the trial judge thought regarding the respective credibility of these two parties, they didn't comply with the statute because there wasn't a diligent search and inquiry as a matter of law. Again, I mean, they're actively communicating with this person at the same time. I searched the cases for something. I've never seen anything as egregious as this in terms of constructive service of process. Far less egregious sets of facts have led to reversals. I mean, again, not to beat a dead horse here, but they are actively communicating with
You and I are
them.
from Ocala anyway, so.
I'm sorry for...
We got horses in Ocala, so you can beat the war. We've heard it. And he actually has family up in Marion County, so we're all horse related here.
Horse country.
You want to be beating the dead horse, I guess, go ahead.
Well, that I'll be even more sensitive about beating a dead horse because I know it might offend your
We're very
sensibilities.
horse-friendly.
Well,
We're a
yeah.
horse-friendly panel.
Well, then I won't beat a dead horse because it might offend you all. But again, it's the notion that they could have conducted a diligent search and inquiry as required by the statute is flatly refuted by the mortgage servicing records. Let me check my... And I think I'm done here. Again, you know, the Beneventi case, they say that and again, this was when they're talking about the facial sufficiency of the affidavit. If something is patently inaccurate in there, that was to the first prong of that. And we think it's patently inaccurate. If I can make one other point on diligent search and inquiry, if I'm searching for someone and trying to find them, I would say the top 3 ways that I would look are a basic Google search, I would get their phone number, and I would get their email. That's the top 3 for me, and I think in modern society that is the top 3 ways. When you're trying to communicate with someone or find them, that's what you need to do. That's the starting point. If they had done that, they would have found that he lived there. They would have found that they had his actual email address on file, 2 different email addresses. He has a Navy email address that they had kind of communicated with him, and he had a Yahoo address. They had 2 different email addresses on file, and they had a phone number on file. And in fact, they were using both the email address and the phone number to communicate them, again, contemporaneously with what they're saying in their affidavits where they're saying that
I mean,
they can't
at
locate
the end
him.
of the day, they could have talked to your client and said, hey, look, we need to serve process with you. We'll meet you at such and such a place. And then if all of a sudden your client becomes scarce and the card's in the door at the house and it keeps staying there,
Right.
then your position is weakening because they've made efforts to try to get a hold of your guy and all of a sudden he's not. But
Exactly.
but right now, they know where he is. They're communicating with him about working out, resolving the default in the mortgage, and all the while the meter's running. And then they don't take the extra step to try to personally serve him
Well, that's exactly
when they
right.
could have. I mean, yeah.
That's it. I mean, that's if you boil our case down to its essence, it's what Your Honor just said. It would be a different thing if he were in the wind, if he were, if there were evidence that he were actively evading service of process, and they attempted to contact him by known methods of communicating with him. Our position would be quite different, and I would probably be taking a different approach in this oral argument. But as it stands right now, I think that it's an easy case, in my opinion. I mean, if the statute calls for a diligent search and inquiry, and they have active methods of communication and are actually using those methods of communication, they can't satisfy the burden as a matter of law. Your Honors, I don't believe I have anything further.
Good deal.
Pardon
All
me?
right. Fair enough. You don't have to use all your clock just because you got it. You don't have to use it. We're
Yeah.
good. I think we've, using your phrase, we've beaten the dead horse.
So, Your Honors, just to kind of wrap up without putting a bow on it, we would ask
I'd like us to reverse and remand it for further proceedings.
took the words right out of my mouth, Your Honor. Thank you.
I've heard this before. All right. All right, thank you, counsel.
Thank
Have
you.
a good day, everybody. Welcome back.